let's talk about some international news with a local context. And this is with regards to the Chinese debt. Kenya debt owed to China. We know that there are billions of shillings that we've borrowed to finance various infrastructure projects, and this is from China. And then we also know that there have been questions and push to have some sort of transparency in the kind of deals that Kenya has entered into with its lenders. For example, the Exim Bank of China. For example, if we talk about the SGR project, the Okoa Mombasa coalition, which brings together several civil society organizations, has gone to court basically seeking to compel the government to release the contract for SGR. What are the details? How much have we borrowed? And what are the repayment terms? And what if we default? What happens? This is at the back of the global conversation that has been spearheaded all over the media on something that's been sweetened and christened as the Chinese debt trap. And the conversation goes that, in these countries, when you have debt with where you've taken some loan from China, there's some conditions that where governments are signing off some key infrastructure. In the event of default, then the Chinese government or the Chinese Exim Bank or Chinese corporations will start to operate some key infrastructure. Remember the issue of Sri Lanka and the port in Sri Lanka, and saying that because of the Rajapaksa family and their government borrowing heavily from China, they got to a point where the Chinese authorities started to take over the operations of the port in Sri Lanka. Is it true or is it not? In Kenya, there was a talk of SGR and our port of Mombasa being collateral. And the question has been asked, is it true or is it not? The president himself has said, absolutely not true. What are you people talking about? The details of these contracts have not been released. At some point, in one of the reports by the former Auditor General, it seemed to mention, the then Auditor General in the 2017-2018 audit of the National Ports Authority, he warned that the Port Authority's assets, of which the Mombasa port is the most valuable, risked being taken over by the China Exim Bank if Kenya defaulted on the $3.6 billion railway loans. The port is East Africa's main international trade gateway. It was launched in 2017. This SGR was intended to seamlessly link the port of Kenya's capital to Kenya's capital, Nairobi, and other parts. Now, there is a team from Johns Hopkins University led by Deborah Brautigam, who is the director of China Africa Research Initiative, who've been working on this and seeking to get the details and understand, is it true or is it not? Now, Ms. Deborah Brautigam's article was published in The Conversation, and the title is Mombasa Port, How Kenya's Auditor General Misread China's Standard Gauge Railway Contracts. I'll read 2 or 3 paragraphs of this. The Kenyan fears mirrored another tale widely circulated earlier in 2018. In that story, China was said to have seized the Hambantota port in Sri Lanka when the island nation had trouble repaying Chinese loans. This debt trap diplomacy allegation was later shown to be a myth, but not before it sparked fears about other large Chinese projects. The Chinese and Kenyan governments both denied that Mombasa port was collateral, but they offered no explanation. Perplexed by the leaked letter, our team of scholars and practitioners of international commercial law and project finance spent months collecting primary documents and mapping the project's contractual structure. To our surprise, she says, we found that the collateral rumor stemmed from a seemingly tiny but critical misreading by the Auditor General. The chief auditor mistakenly labeled the Ports Authority as a borrower responsible for repaying the Chinese railway loans. He charged that by waiving sovereign immunity, Kenya's government had expressly guaranteed that the Ports Authority's assets could be used to repay the Chinese loan. The Auditor General was mistaken in both targets. For the Auditor General and many others, the debate over the railway and Mombasa port was complicated by technical terms and practices. These are used routinely in the law and business of international project finance, but are unfamiliar outside these arenas. So people who don't really understand these things may get confused. Now, we will be speaking to Ms. Deborah shortly, who's joining us via video link from the US. And she'll explain this to us. But here, and after reading this article, guys, what comes to mind, City?
Well, that last bit that you read, that directly talks about technical terms that is often used in the world of finance. You're talking about project finance. You're talking about business finance. To a layman, it's financing a project, financing a business, and in many people's minds, a business is a project. And yet, clearly there are details, and specifically what it is that is actually used for collateral. Most people think you need a fixed asset, you need a building, you need land, you need a port, whereas that may not necessarily be the case. Sometimes it is what it is that particular entity is able to realize in terms of income, that is what provides the security. Because the building in itself is nothing except a building. Its net worth is fixed, but the business that it does and what it generates, that in itself can provide adequate security, or it can provide competitive security if it's then needed. But then you require experts to explain many of these things, and I am certainly not an expert.
Yes. She says, although some public education would have been necessary, releasing the contracts, which Kenya's High Court ordered the government to do just last week, might have prevented the Auditor General's mistake and would have allowed debate on the facts rather than rumors. The four key stakeholders in the financing of the SGR were the National Treasury, who was the borrower, the Kenya Railways Corporation, that's a project company, the Kenya Ports Authority, and China Exim Bank, the lender. The figure, she puts a figure that shows the complicated contractual and payment arrangements. Now, the question for me is, Wanjiru Gekonyo and Halif Khalifa and the others have been trying for months, in fact going into years, to get details of this contract. Is she implying that she and her team of experts from the Johns Hopkins University were able to get these contracts?
To be able to have understood in the details,
yes,
that they say they have understood it.
Yeah, the deep contractual legalese arrangement of what exactly is happening. So how do they get to know about this?
It's a valid question.
Yeah, because if we're really talking about, okay, so many people don't understand what this contract is all about. And of course, many people are not technically versed to it. Even if this contract was actually published today, not many people would understand it.
You'll read it and simply not understand it. Or you'll understand it along the lines of whatever knowledge you currently have on such a subject. That's what you'll base your understanding on.
Sure, but you can't also run away from the realities that the technicalities that you speak about, which we often see in a lot of these financial documents, sometimes are done deliberately. That you wrap up the knowledge, or you wrap up what would be understanding in technical jargon. Because what it does is that it throws you off from the very beginning. Unless you're really vested in finding out what the details of all of this thing is when you're probably going to delve a little bit deeper. But if once you start to go through it, you're hit in the face with all these technicalities, the likelihood of you putting it aside is very high. So then you have to ask, was it deliberate? Was it deliberate, or is it deliberate on many counts to make it so technical so that you don't have an understanding? Or that it is hidden in plain sight so that you don't see it? Or that this misunderstanding that everybody talks about also then was planned. We don't want you to understand so that you don't really know what is going on and what was signed for.
Let's see if we can get Deborah on the line. Deborah, good morning.
Good morning.
Thank you very much for joining us, Deborah. Deborah Brautigam is the Director of China-Africa Research Initiative at the Johns Hopkins University. And we are talking about this article of yours that was published on The Conversation, which is a publication that looks at various conversations around the country and the globe. Specifically, yours is saying that Kenya's Auditor General misread the details of the contract with the SGR. Just take us through the details. First of all, what had the Auditor General said in that audit report of 2017-2018? And then what did your team do?
Well, I think we have to back up a little bit to look at the letter, the management letter, because for most Kenyans, that's the only part of the audit report that's ever been seen. So the management letter is what was leaked in 2018. And so that's what led to this whole idea that Mombasa port was collateral, because the management letter is where these mistakes were first circulated. And so the management letter is something that accompanies the audit of the Kenya Ports Authority that was being done that year. And so the auditor is supposed to point out all of the risks that the company that's being audited faces. And so what they pointed out in this management letter were several things. One was they had some questions about the risks that they wanted Kenya Ports Authority to answer. And the second thing was that they pointed out some risks that they understood. And so from this letter that was circulated by a whistleblower at Kenya Ports Authority.
Yes, go ahead.
Am I still on?
Yes,
Yes,
you
you
are.
are.
Okay. This letter stated fairly clearly that the Auditor General believed that Kenya Ports Authority and the Kenyan government had put Kenya Ports Authority's assets at risk in the standard gauge railway as essentially as collateral for the standard gauge railway contract, which was financed by the Chinese bank, China Exim Bank. And so this letter circulated, but the Auditor General's report that was attached to the letter and eventually finalized a few months later was not released for another 2 years. And so the report itself provided enough information for us to figure out what was going on. But for 2 years, this leaked letter, 3 pages of this letter, was the only information available. So that's a little bit of the background for this puzzle. So let me point to one particular thing that the Auditor General said. He said that Kenya Ports Authority was a borrower on the standard gauge railway loan. And so we, in the leaked management letter, we were very perplexed by why he would say this. There wasn't any evidence. But the audit report 2 years later provided us with the explanation. And what happened in the audit report was that it became clear that the Auditor General had misread a small clause in the contract. It's more a matter of English than of technicalities.
So even your own research, Deborah, did you get to see the contract that has been signed between whoever the borrower is in this particular case? This is the National Treasury and the China Exim Bank.
Deals like the standard gauge railway have many different contracts. And so what the legal side of our team pointed out that these contracts could go for 1,000 pages or so. So there could be many different components, maybe even a dozen. And so it's not just the particular loan contract, it's the contracts between Kenya Ports Authority and Kenya Railway Corporation. There's the payment arrangement agreement. So there are many different ones. We had access to some of these contracts. We didn't have the actual loan contract. However, we have pieces of it that were released by people who have seen it. And we also have seen many Chinese loan contracts, more than 100 that we've read. So we know how they work in general.
Okay, just take us through the basic structure of how such a contract would work, because I guess the fear here, even what the management letter by the Auditor General was raising, was with regards to the repayment. Let me just read an excerpt of what the leaked management letter was saying. The payment arrangement agreement substantively means that the Kenya Ports Authority's revenue would be used to pay the government of Kenya's debt to China Exim Bank if the minimum volumes required for consignment are not met as per Schedule 1. The China Exim Bank would become a principal in over KPA if the Kenya Railways Corporation defaults in its obligations and China Exim Bank exercises powers over the escrow account security. KPA assets are exposed since the authority signed the agreement, where it has been referred to as a borrower under Clause 17.5, and any proceeding against its assets would be the lender would not be protected by sovereign immunity, since the government waived the immunity on the Kenya Ports assets by signing this agreement. Basically, the fear here is when it comes to payment, if Kenya Revenue Authority is not able, if Kenya Railways Corporation is not able to get cargo onto the SGR that then meets the revenues required to repay the debt, then we'll start going into the other corporations. In this particular case, the Kenya Ports Authority.
So the particular contract, one of the contracts that we have is what's called a take or pay agreement. And that's between Kenya Railway Corporation and Kenya Ports Authority. So it's one of the contracts in this whole complex that we mapped. And I think that's one of our contributions, the mapping of these contractual relationships. So it's complicated. There are a number of different actors here. So Kenya Ports Authority and Kenya Railway Corporation have a take or pay agreement. That's the only contract that Kenya Ports Authority is liable for.
What does it say? What does take or pay mean?
The take or pay means that these are common clauses. They're very standard in international project finance.
Yeah.
For example, if you have an international bank providing a loan for an electricity project, they want to be sure that there's a buyer for the electricity.
Yeah.
So they ask the producers, say of the hydropower, to sign a contract with a buyer.
Mm-hmm.
So it might be a utility company.
Yeah.
And so the buyer agrees to take the service, take the power for a certain period of years, say 15 years, 20 years, or the term of the loan, in order to provide a guaranteed market for the hydropower project. And therefore the bank will say, okay, you've got a market, it's guaranteed, now we think this is a bankable project because we know you're going to have revenues.
Mm-hmm.
So when China Exim Bank is looking at Kenya Railway Corporation and the Kenyan government is the borrower, but the Kenyan government wants to on-lend the loan to Kenya Railway Corporation. So China Exim Bank says, well, Kenya Railway Corporation is a money-losing company. We don't want to lend to Kenya, and you're going to on-lend to KRC, and how are you going to repay the loan? So they arrange this take or pay agreement with the railway's major client. So Kenya Ports Authority is the major client of the railway. It's not all of the passengers. That's not a profitable part for the project. It's the freight. And so it goes seamlessly from the port onto the railway, off to Mombasa and beyond. That's where the revenues are generated. So then Kenya Ports Authority signs that agreement, just like the utility. They promise to take a certain amount of the railway services for 15 years. And if they didn't take that, they would have to pay what they guaranteed to take. They have to pay the same amount.
Okay.
So that's a take or pay agreement.
Okay.
So that's one important part of this. But that is
so Deborah, are we saying in essence, if I can just make a clarification here, that in terms of collateral, we are not saying that KPA and its assets then were put on the table in the event that there's default. that KPA and its assets then were not collateral for this loan agreement.
That's absolutely correct.
Okay.
KPA's only role in this project is to serve as the client of Kenya Railway Corporation and to take that service or pay KRC. So they're not even directly paying China Exim Bank.
Yeah.
So it's going into this escrow account.
Okay.
So that's, and so what the Auditor General got wrong when, in that piece that you read,
Yeah.
he said if KRC defaults in its obligations, then KPA is liable somehow. But that's not correct. KPA is only responsible for the amount of freight that it signed in the take or pay agreement.
Mm-hmm.
It doesn't have any responsibility to repay the loan. It has a responsibility to pay Kenya Railway Corporation. And then Kenya Railway Corporation is part of the structure of repaying the loan, but the loan is essentially being repaid out of the Railway Development Levy.
Mm-hmm. So we're going to take a break shortly, and then we come back and get into the finer details of this, because clearly there are several layers of this. You have experience having seen several other Chinese loans or loans lent by China to several other governments and corporations around the world. And you're telling us what you're seeing here is similar to what you've seen elsewhere. But also, let's look at the context, Deborah, that globally, this has been termed as the debt trap. So is it possible that, some of these contracts, all of them that you've seen, also have a way of making sure that, if you're not able to do this, then other parts of your infrastructure are also lied to or tied to this loan? That's a conversation we'll have after this quick break. Thank you very much for joining us, Deborah. Stay on the line.
This is the Situation Room, the only way to start your day.
Eric Latif Nduoko CT Muga. Our guest joining us from the USA is Deborah Brautigam. She's a director, China Africa Research Initiative at the Johns Hopkins University, and she's talking about a leaked report in around 2018 on the Auditor General's management report from KPA, where he seemed to have raised concerns about the kind of relationship between the Kenya Ports Authority, the Kenya Railways Corporation, the China Exim Bank, with regards to the SGR project. And Deborah is saying, well, we have seen several other contracts of this nature, and just looking at this particular one, nothing untoward really. The relationship that she has explained so far between this whole and all these entities, Kenya Railways signed a deal with the Kenya Ports Authority that the Kenya Ports Authority is going to supply cargo and freight onto the SGR of a certain amount over the next X number of years. And the deal is take or pay. You bring the cargo onto me, or you pay me if you don't bring me the cargo. Now, there's a diagram that you have published here in your article, in the conversation, Deborah, which is quite complicated. The complicated contractual and payment arrangements between the various entities in government. If I just look at it, primary loan agreement is between the Exim Bank and the National Treasury. That's the borrower. That's the government of Kenya. The Railway Development Fund is what's supposed to repay this loan. Then we have a line here with the Kenya Railways Corporation, an escrow account, loan payment, that is principal and interest, going into Exim Bank. You have four parties payment agreement, and this is between the Exim Bank, the Kenya Ports Authority, the Kenya Railway Corporation, the National Treasury, who's the borrower. We have the on-lending loan. You've got the customer. It's like you said, even in your own diagram, it's complicated, Deborah. Just break it down. So who pays the loan? Who's taken the loan? Who pays the loan? Who repays in the event of a default?
The National Treasury is the borrower, and so they are responsible for repaying the loan. And I think there's another really important aspect about this confusion, and it's happened in many countries, actually. We can see confusion about Chinese loan contracts happening in Uganda with the Entebbe airport contract. We see it happening in Montenegro with a big highway contract, and even in Zambia with several of the contracts there.
Yep.
And this confusion is about a second legal clause, which is quite misunderstood. It's called a waiver of sovereign immunity.
Mm-hmm.
Now, when I first heard that term, waiver of sovereign immunity, I thought, what is this? I have a PhD, and I've never heard that term before. So I had to consult. I had to consult with legal colleagues, other professors who teach in the international law program. I said, "What does this mean?" So they explained it to me.
Okay.
And they said, this is a very standard phrase that is in all international commercial project finance contracts and many other kinds of international contracts. And why do they have this? They have this because sovereign states, under international law, they have sovereign immunity, which means two things. They can't actually be sued in court in other countries.
Mm-hmm.
So the government of Kenya or other governments, if a bank, if they don't pay, say, and a bank wants to bring a lawsuit, they can just say, "Oh, sorry, we're immune from this. We have sovereign immunity. Bye-bye."
Yeah.
So every bank, and then the second part of it is even if, say, there was a lawsuit and the government of Kenya didn't show up because they said we have sovereign immunity, we're not coming, and the judge said, okay, you still have to pay, they have immunity from enforcement. So they don't have to actually enforce any foreign judgment either. So they don't. So because they're immune from these things under international law, these contracts contain a waiver of sovereign immunity. Now, this is very, very standard. It just means if there's a dispute, it doesn't even have to be a default, it can be any dispute, that it can be arbitrated or litigated outside the country. So no one will actually give a loan without that.
But Deborah,
no international bank,
you
whether
say
they're Chinese or
you say over the very many years of practice and academia, you had never come across such contracts until contracts involving loans with China were involved.
That's because my expertise is in China and Africa. I'm not a lawyer. So my colleagues all said to me, who have been involved in my law colleagues, they said, "Oh yes, we've been doing this for forever. This is what international lawyers, commercial lawyers do. We write contracts like this, and they all have the waiver of sovereign immunity. It's absolutely standard. In fact, they said, if you didn't put this into a contract, it would be grounds for professional malpractice. So it's so standard. Now, why didn't I know about this? Because nobody's really looking into these contracts. It hasn't become an issue because I'm not sure why, but it's not been out there as a concern.
Deborah, what you say is easy.
Not just that-
Sorry, go ahead, please. I'm saying,
Just that it's
yes.
No, you go.
Oh, no. I insist. You go first.
So I'll make one more point about this. These things they're very technical and complex, and these legal terms, amongst lawyers, they use these terms all the time. It's the language they speak. But we lay people don't speak that language. We don't speak with lawyers in that language unless we're buying a house or we don't have this technical expertise. I didn't have it. most people don't have it. So that's why our team had to bring in a lawyer to explain how all these things work.
Okay.
And that's how we were able to find out that apparently the Auditor General did not consult his lawyers because he also did not seem to understand this waiver of sovereign immunity.
Okay. Now, you mentioned that in the event of there being an issue, the way of resolving it would be to go to arbitration.
Mm-hmm.
Now, is that the worst case scenario? Meaning, country has borrowed money, they have defaulted, or there are issues in payment, and the only thing that can actually happen is that they'll go to arbitration. There are no clauses that allows the lender to take any other action that may be deemed punitive beyond arbitration.
That's correct. So arbitration will then, if there's a dispute, it will be arbitrated. So there will be, it's usually three different, if Kenya defaulted on this contract, they would go to arbitration, and Kenya would appoint a lawyer, and the China Exim Bank would appoint a lawyer, and the two of those lawyers would then agree on a third. So there'd be three people. And they would, and then the case would be discussed and arbitrated.
Deborah, can we come from the point? I mean, just what you've said, that you have, you've dealt with information like this from other quarters as well. Now, we talk about the technicality of some of these contracts, which, by design, is done with a lot of legal jargon. Is this deliberate to get to a situation where folks just actually don't understand what is in those contracts? I'm asking this question because if we look on this side of the pond, there's quite a lot in terms of speculation as to the reasons why the information is not plain as day. Why make it so difficult to understand if it's something so simple, like you've told us, that, it's take and pay, and that it should be clear in the event of a default, this is what would happen. Do you find that they use this language in a deliberate manner, or it's just the way things are?
There is nothing uniquely Chinese about this. This is what lawyers do. And they all get together, they all speak Latin. They don't speak Latin literally, but they have all these Latin. It's not in order to try to mystify those of us that aren't lawyers. It's just that this is developed into their own language. Just like economists use all of these technical terms when they're talking, or finance people. And they're not always understandable to people who don't understand, net present value, internal rate of return, and so on. So it's not a deliberate effort to mystify. It's a technical expertise. It takes 3 years to go to law school and learn all that stuff. So I think maybe there's some they are trying to protect their business by making it a little bit
their trade.
So we have to hire other lawyers in order to understand these contracts. But have you ever taken out a credit card, and have you read all of that? Pages and pages of things that you've signed.
Always complicated.
Legal agreements.
Always complicated. Deborah, I want to ask, you've looked at other contracts, or you've looked at other deals. Let's say just the ones you've mentioned in Uganda, over the Entebbe airport, in Zambia, in Montenegro, in Sri Lanka. What the key issue here, even as you look at the global conversation about the debt trap, what is chalked into these contracts as a way out in the event of a default?
Well, in any loan default, whether it's the World Bank or the IMF or, China Exim Bank or Citibank, there will be an arbitration of some kind. There will be, discussion. And what actually what we know from other lenders, for example, the Germans, there's an example that I was following in Zimbabwe where a German bank lent to a Zimbabwe project and Zimbabwe didn't pay. And so it did go into arbitration. And the German bank, KfW, did get a judgment. But then the problem arises for the international bank. How are they going to enforce that judgment? They can't just go to Zimbabwe and grab, this was a steel mill. They can't just go and grab the steel mill. You know, it's just not feasible. And so what they try to do is they try to what's called attach assets outside the country. So it might be Zimbabwe Airways plane. Or in this case, they tried to attach some houses in South Africa that were owned by the Zimbabwe government. But they failed. The South African government wouldn't, their law courts wouldn't enforce it for Germany. And so that's likely what would happen in Kenya if there actually was a default. It wouldn't even, for the Chinese, it wouldn't even go to court. There would be discussions about it, and the Chinese would extend the terms of the railway loan. That's what we see happening in the Chinese cases. They just extend the terms. They give countries a longer time to repay it.
You know, from what you say, essentially, the whole issue arose from simply one discipline explaining what it is they do in a language that they understand, and another discipline trying to interpret it without having the knowledge that other discipline has. And then when you throw it into a setup like ours, where there is a decent amount of mistrust for the government, so it is far easier to believe the narrative that certain national assets had been hawked off, certain national assets had been put as collateral, and should there be a default, they would be taken. So have I summed this thing up correctly?
That is just an excellent summary. And I would point to mistrust, which has another element, which is that the Kenyan government has never released all of these contracts. Unlike, for example, Cameroon, which released all of the contracts from China, the World Bank, from all of the lenders, and they were posted on the internet. So if they had released the contracts, there would still be a lot of confusion because these contracts are really complicated. But then the lawyers in Kenya could explain it all on shows like yours. And it wouldn't have to be people like me coming in from outside to do this research.
I'm interested in knowing, Deborah, when you say that you got access to, some elements of these contracts, how did you come across these contracts when there have been bodies in this country, institutions and organizations that have been seeking transparency on these contracts and have even gone as far as going to the court to demand that these contracts be released? How did you and your team get access to them?
Well, there are two answers to that. One is that the loan contract was obtained by someone at the Nation, I think was the Sunday Nation, and he quoted pieces of it. So we have some important clauses from the loan contract that he quoted in his report. So we have some of that. And and then we saw these are the same as the contracts we've seen 100 other contracts. It's very, very normal. But the second thing is that we got a copy of the take or pay agreement. We have the actual contract. This is a totally Kenyan contract between two Kenyan corporations. So I think it's not as, perhaps as held as tightly. So we were able to obtain that. So those are, and then there are a few other pieces that the Auditor General had. He had a third contract, the four parties payment arrangement. So that was released to the Auditor General because Kenya Ports Authority was a party to that. Now, the Kenya government did not release the loan contract to the Auditor General because Kenya Ports Authority is not a party to that. So according to the Kenya government, the Auditor General doesn't need to see the loan contract.
Now, when it comes to the take or pay, in fact, we have issues maybe with that. Number one, it's the details of a take or pay agreement. We have currently the conversation in the country is a take or pay agreements that have been signed between independent power producers and the power utility company Kenya Power. And the issue has been renegotiated is because it becomes too expensive how much you've committed to taking or paying. The question is a take or pay the only way we could have this contract done, or could you have any other way of arranging to make sure that the railway is actually operating, it's getting its business, but also to make sure that Kenya Ports Authority is not tied to putting all its cargo there. If the customers of Kenya Ports Authority do not want to use the railway, then what? Kenya Railways has to pay? Kenya Ports Authority.
This project needed all of these other what is called credit enhancements in order to be bankable. Just the railway company on its own cannot repay this loan. They're not going to. The standard gauge railway is not going to make enough revenues just through passengers and freight to repay the loan. So that's why the bank said, you have to do something else, or else, it's not a bankable project. So that's where the Railway Development Fund becomes very important. And it's been very important since 2013. It's been public. This is in the parliamentary records, all of these credit enhancements, the details of the offtake agreement, they're all in public records at Parliament.
Okay. I have a call on the line.
So we have made a lot of those.
Deborah, there's a call on the line. Let's hear what Alan would like to ask. Alan, good morning.
Good morning.
How are you, Alan?
I first heard of Deborah from her book, Gifts from the Dragon.
Mm-hmm.
I think she. The problem is that she is splitting hairs. And the reason I think so is the following. The take or pay, one, she has not seen the contract. Two, the take or pay agreement, the point the auditor was making is that the take or pay agreement is a contingent liability on the books of KPA. Today, the IPPs you are talking about, Eric, Kenya Power signed, has been signed between Kenya Power and the IPPs. Yet, they are contingent liabilities on the books of the government. So, even though technically KPA's asset, the physical collateral has not been pledged, all assets of the government are exposed. You remember what happened to us with the Anglo-Leasing contract? When the Anglo-Leasing company wanted to take over our embassy. The point is, the state remains exposed. All assets, including KPA, are exposed if there's a default.
Let's hear what Deborah has to say on this. Deborah, respond to this.
I think there's a big difference between a specific asset being used as collateral, for example, Mombasa Port, and a very general, the sovereign immunity waiver, which states that all of Kenya's, everything owned by the government is potentially at risk. So what the caller is suggesting is that, this is I suppose it's true that in a very vague way that everything that the Kenyan government owns anything might be at risk, but in practical terms, it's like anything. But you know, in practical terms, it's really not the case. So if it was a collateral, you would have to have a lien on it. It would have to be registered. You know, it would be very specific that you know, the loan default, boom, you have to give up the collateral. But you can imagine if there's a default situation, you're not going to be, Kenya government is not going to be saying, okay, China Exim Bank, just come here. What do you want? Do you want this building? Do you want that highway? Do you want to? It just doesn't work that way.
Pick something. Thank you very much, Deborah. Sorry, as you
Can I
conclude.
say one more thing about the you have to conclude?
Mm-hmm. Yes, we've got to conclude now.
Oh, okay. The contingent. Okay. All right. I'll stop.
Well, Deborah, thank you. Thank you for joining us and thank you for speaking to us.